ensure the subclass 457 visa program is not being misused. Employers who do not comply with this rule may be subject to fines and penalties. Requiring visa applicants to input the details of a nomination by a sponsor or a proposed sponsor when submitting online visa applications in order to streamline the overall processing of subclass 457 visa applications. And the last, sees the English language proficiency requirement for subclass 457 visas. Applicants were already required to prove such proficiency to obtain occupational registration or licensing. As I said in my introduction, that each day there are some changes in the immigration rules. So this slide, I'm going to talk about changes to subclass 457 accredited sponsorship scheme. On July 1st, 2016, Department of Immigration and Border Protection, DIBP, implemented changes to subclass 457 visa accredited sponsorship criteria. Subclass 457 visa sponsors with a long history of good dealings with DIBP are eligible to apply to become accredited sponsors. Benefits: longer period of sponsorship approval, which is 6 years, and all nomination and visa applications receiving priority processing. Existing sponsors who meet the new qualifying criteria as of July 1st for accreditation should lodge a sponsorship variation application seeking to be considered for sponsorship accreditation. So here's a list of changes to 457 accredited sponsorship scheme. The employer must have been an active sponsor for at least 3 years, with no more than 6 months break in the past 36 months, with no adverse information based on monitoring, including formal warnings and sanctions. The number of sponsored 457 primary visa holders have been lowered substantially to 10 in a 24 months period. Previously, it was 30 in 12 months period. At least 75% of employers' workforce must be Australian nationals. All 457 visa holders to be employed under a direct written contract of employment that meets the national employment standards, as opposed to on-hire arrangements. All Australian employees must be paid in accordance with an enterprise agreement or an internal salary banding structure that reflects current market salary rates. Existing sponsors who meet the new qualifying criteria for accreditation should lodge a sponsorship variation application seeking to be considered for sponsorship accreditation from July 1st, 2016. Companies that have already obtained accreditation should apply for an upgrade to their sponsorship from July 1st, 2016 to get the new benefits. As you see, nomination applications lodged by sponsors that are approved for accredited status after July 1st will be prioritized and further streamlined processing given to applications where the base salary of the nominee is equal to or higher than, first, the Fair Work High Income Threshold, it's $113,000 at July 1st, and the occupation is classified at Australia and New Zealand Standard Classification Occupation, skill level 1 or 2. And two, $75,000, and the occupation is classified as Australia and New Zealand Standard Classification Occupation, skill level 1 or 2, with the exception of the following occupations: recruitment consultant, sales representative, industrial products, customer service manager, corporate general manager, procurement manager, quality assurance manager, sales and marketing manager, specialist manager NEC, hotel motel manager, contract administrator, information and organization professionals NEC. Australian immigration has proposed temporary visa framework to simplify application process. The Australian government has reformed some of its subclasses, replacing of some sponsor classes and removing certain sponsorships and nomination requirements for specific short stay activities, subject to the approval of Governor General to make applying for a temporary visa easier. Applications that are received before 19th November 2016 will be processed under the pre-temporary activity visa framework and will be approved until 18th May 2017 or until the pre-November 19th November 2016 sponsorship ceases, whichever is earlier. This slide talks about Australia new visa subclasses. So there's a brief explanation on each subclass. Subclass 400, temporary work short stay specialist visa. Foreign nationals may use this option for short-term, highly specialized, non-ongoing work in some cases, may participate in an activity or work relating to Australia's interest. Next is subclass 403, temporary work, international relations visa. Foreign nationals that have bilateral agreement, represent a foreign government, teach a foreign language in an Australian school, diplomatic work, or to participate in the seasonal worker program. For this subclass, nomination and sponsorship is required. Subclass 407, training visa. This subclass visa for people intending to train or participate in a classroom-based professional activity. A single sponsorship, the temporary activity sponsor, will soon replace the current sponsorship types: long stay activity, training and research, professional development, entertainment, special program, and super yacht crew. Nomination and sponsorship is required regardless of the duration of stay. Paper applications will no longer be accepted for sponsorship of temporary activities after 19th November 2016. Sponsorships will have to be applied for online at IMI account for approval. Tuition fee for school-age dependents of 457 holders. In 2015, the Western Australian government introduced a tuition fee for families on a 457 visa, temporary skilled workers, whose children attend public schools in the Western Australia Territory. In a similar step, beginning Jan 1st, 2017, the South Australian government plans to implement a tuition fee for families in Australia with a 457 visa whose children attend public schools in the South Australian Territory. The tuition fee will extend to all subclass 457 visa holders beginning Jan 2018. Families with dependent school-age children attending a government school will soon be obligated to pay an annual contributions. The annual contributions beginning Jan 2017 are: primary school, 5,100 per student Australian dollars, and high school, 6,100 per student Australian dollars. A family that does not make a combined annual income of at least 57,000 Australian dollars are exempt from paying the contribution fee. The full rate of the contribution fee goes into effect once a family's combined annual income is equal to about 77,000 Australian dollars. The combined annual income increases by 10,000 Australian dollars for each additional child. A waiver of the tuition fee contributions is available to families that experience hardships. The waivers are granted in exceptional circumstances, but can help families that can afford the tuition fees. This concludes my thoughts on this topic. I'm sure that after listening to the presentation, you would have a fair idea of the current scenarios which I spoke about. As I said earlier, the immigration scenarios keeps constantly changing, and it is going to change forever. The key, ladies and gentlemen, is to try and be as compliant with the laws so that you and your firm's interests are not harmed due to this. Thank you. Thank you once again on behalf of our firm and myself. Rama?
Thank you, Ketaki. Over the last 2 days, we've all discussed a lot about outbound immigration from India. So we've talked about movement from India to US, UK. I will, in the next 10 minutes, give you a brief overview of inbound immigration into India. So what we will cover I'll touch upon employment visa versus business visa, some of the practical challenges and issues associated with immigration in India. While in India we have a lot of short-term visas for foreign nationals who want to visit India, like project visa, research visa, conference visa, but anybody who wants to work in India is required to get an employment visa. Employment visa has to be applied for in the home country of the foreign national, and it is not available for jobs. It is available only for highly skilled foreign nationals, not available for jobs for which high number of qualified Indians are already there, and also not for routine and administrative jobs. Like most countries, India also has a minimum wage requirement of USD 25,000 for anybody to qualify for an employment visa. And of course, without mentioning it, all the tax and legal compliance requirements have to be met. On the other hand, business visa is for people who want to visit for short durations, for exploring business opportunities in India, recruitment of manpower, coming in as trainees or technical or board meetings. Also for ongoing project work, but it is not to be used for any kind of employment activities in India. I will not spend too much time on this because we all know consequences of wrong visa could lead to bad repute, fines, deportations, and penalties for both the individual and the organization. So some of the practical challenges versus ideal practices have been listed on this slide. And this is what we see very commonly on a day-to-day basis, and I'm sure most of you would have encountered this. Now, any foreign national who comes to India on an employment visa, if he or she wants to get his or her dependent, they need to come on an entry visa, commonly known as the X visa. A common practice which we have noticed is that the spouses with the availability and facility of work from home these days come into India on an X visa and work in India while they are on an X visa. This practice is definitely wrong because dependent visa holders in India are not permitted to do any kind of business or economic activities. The next challenge is, of course, getting non-married partners. People from the West would want to come with their live-in partners. India does not recognize this concept. But in few exceptional cases, we have noticed that the embassies, in consultation with the MHA, are accepting documents. For example, in one case, we were able to furnish the birth certificate of the child, which mentioned both the partners' names as father and mother. So that was accepted. But commonly, it is a challenge to get a dependent visa for a non-married partner. And the next two challenges, I'm sure most of you would have encountered: foreign nationals visiting India on business visa and performing employment activities. This is a practice which should strictly be monitored. I'm sure most of you are doing it and should be discouraged. Any business visa holder should not be doing any employment related activities. Conversion of a business visa into employment visa while being in India is also not possible. So they should go back to their home country, apply for an employment visa and come into India. The other practical challenge is to have foreign nationals who have a work permit which is not a residence permit in India which is not expired, and they may visit India again to look for opportunities with other organizations. While there is no deregistration process in India in most of the cities, as a good practice, we would recommend that you inform your employees to hand over their residence permit once they leave India for good. A couple of minutes on FIO registration. I'm sure most of you are aware of it, that any foreign national who comes to India on a visa which is valid for longer than 6 months, or the visa has an endorsement saying registration is required, need to register within 14 days of their arrival. Visa extensions are also possible by being in India and not going back to the home country as was earlier required. Failure to comply with FIO registration can lead to both penalties and imprisonment. Now, I'll quickly touch upon some of the challenges that we are seeing. Amarpal did speak about some of them yesterday, but just few points. So the most important challenge that we see is lack of guidance and clarity on concepts. While there are FAQs available on a business visa and employment visa, there is not much clarity on what certain terms mean, such as somebody can come to India on a business visa for short duration. A business visa is available for 5 years, so what is the meaning of a short duration is not clear. An example here would be a person who wants to come in as a trainee in an MNC can come on a business visa, but somebody who wants to impart training, there is no clarity on what visa he needs to come on. The next two bullets talk about a disconnect between the tax, immigration and social security authorities, not in terms of exchange of information. As Surbi mentioned in the session in the afternoon, that there is a lot of exchange of information happening between authorities, but again we have come across a lot of challenge in these authorities accepting the tax and social security positions which are not by the law or which are not available in black and white. For example, asking for a person to submit a tax clearance certificate when he or she is not liable to tax in India. So that is another challenge that we are facing. Getting information, getting standard documentation across the country is a big challenge. Different FIO authorities, it was discussed yesterday, are asking for different documents, and the documentation requirement keeps changing on almost a monthly basis. The other big challenge is to get information from the immigration authorities in India, because as most of you would be aware, the FIO premises do not allow Indian nationals to enter. So if somebody needs some kind of clarification on a matter which is non-routine, then you need to write an email and wait for them to respond. So there is no quick solution to any problem that you may face. So with this, I would request Datta if he could throw some light on what are the challenges he is seeing in his organization in terms of an inbound immigration.
Thanks, Rama. Apart from these, we usually come across different practical challenges wherein HR briefs the expat who comes into India that, in case if the duration is less than 6 months, then they say usually the FRRO is not required. Whereas when the expat lands into the commissioner office and sits in front of the officer, so they will ask for FRRO registration again. So that itself is a big challenge. There is ambiguity surrounding this, like whether FRRO is needed, whether if it is a special case, then it has to be mentioned. But there is clarity that is missing always on this. And also the recent challenge that we see is on the point that you have touched, asking for the tax certificates. So usually this has started from Gurgaon because I faced this